let's talk about routine searching of property before releasing it to a third party. All right, guys. Hey, my name is Anthony Bandiero. I'm an attorney and senior legal instructor with Blue to Gold Law Enforcement Training, bringing the Roadside Chat. So let's talk about this case. It comes from, where's this officer at? It doesn't actually say, but search incident to arrest exception, right? So a suspect is arrested for obstruction. He has a backpack with him, but his friend states that it is actually his backpack and he wants it back. Before returning the backpack, it is searched, incident to arrest, and a loaded firearm is found. Is this search lawful if it isn't his bag? All right. So this one, I want to kind of break up into two kind of categories. One is this, right? It's probably okay under search incident, maybe, right? It gets debatable because why do we search things incident to arrest? To protect ourselves from weapons, to prevent them from destroying evidence, and means of escape and so forth. But here's the deal. You're handing off this backpack to somebody else. So those justifications start going away pretty quick, right? We also have some case law where if the property is being handed over to another person, it's not the search incident to arrest exception is not really very persuasive. So let me just give you my rule here. Basically, if the property is going to be into safekeeping by somebody else, then police need a legitimate reason to search the property before being released, right? If you feel like giving this weapon, you can articulate, not just feel, but you have facts and circumstances that lead you to believe that handing this backpack over would make somebody armed and dangerous against you. Obviously, you can do something with that. If you believe that they have evidence in the bag, then you're probably not going to hand off evidence. If you think they have medications and you need those to go to jail with them, obviously you want those to go with them too, but have a reason. If the bag is simply being, and if there is no search incident to arrest rationale, and the bag, it can be safely handed over to somebody else, and that's what they want to do, right, the suspect, then that's what you should do. Let me give you an example of a case. This is a summary. Warrantless search of a bag which the defendant gave to a bystander who came to her aid after a one-car accident could not be justified as an authorized inventory of a bag's contents, and hence subsequent seizure of drugs from bag was improper, where facts indisputably showed that the need for an inventory of a bag was artificially created to enable police officers to conduct a search of a bag without probable cause. Now, there is a little bit of a wrinkle here. The wrinkle is, in most jurisdictions, we get to search those things under incident to arrest that are in their control at the time of arrest. In some other jurisdictions, like the 4th Circuit, the 10th Circuit, Nevada, and so forth, and some other states, what's happening is that the courts are saying, look, you're probably not going to search that item while they're out of handcuffs and right next to it. You're going to put them, if they're under arrest, you're going to put them in handcuffs, and then they're not going to have any reasonable access to the bag. So those courts are not persuaded anymore that search incident to arrest is the right way to go. However, you can still inventory bags that are going with them to jail. But we are talking about a situation where the person wants their property to go to somebody else, and they are in handcuffs, and the bag is removed from them. What should you do? My recommendation is that you do let the bag go. But Anthony, we're not stupid. We're going to be played here. Like, they're going to hand off evidence, just like this person tried to hand off evidence. And I understand that, but how are you going to go to court and with a straight face, say I searched it anyway, even though I'm still going to let the third person have it, which you should, because it's their property. You should not force people to bring property with them to jail when they have somebody on scene willing and able to take custody of it. So just think about this stuff. So I guess to really finalize my rule is that if you have no reason to believe that evidence is, if you don't have probable cause that there's evidence in the bag, you don't have reasonable suspicion that there's a weapon in the bag, and you have no other compelling reason to search the bag for medicines and so forth, and they have somebody on scene willing and able to take that bag, you should let them take the bag. And you should not have, you don't have authority to inventory. All right. Hope it helps. If you disagree or you have other comments, share them below. Again, that's probably good advice, definitely for my people in the 4th and 10th Circuit and Nevada. For those others that are in those states that have not decided this issue yet, you're making case law. How about you make good case law? All right. So I hope this video has helped you get it right every single time, and I will see you next go around.